Lagos State is considering a review of its tenancy laws, following in the footsteps of Enugu State. Now, this development comes as a response to the growing concerns over rising house rents in the state. The proposed review aims to protect tenants from exorbitant rent increases and ensure a more balanced relationship between landlords and tenants.
Here's what you should know. Enugu State government has amended its Landlord and Tenant Act, introducing a 10% ceiling for agency and legal fees, prohibiting caution fees, and setting defined duration for notices. Lagos State plans to review its tenancy law, focusing on addressing rising house rents and protecting tenants' rights, drawing inspiration from Enugu's reforms. The proposed review may lead to more affordable rent options and a more regulated rental market for both tenants and landlords in Lagos. Now let's get into this discussion with our guest, Ireoluwa Oguntuase, a legal practitioner. A warm welcome to the show, Mr. Oguntuase. Thanks for joining us.
Yes, thanks for having me. Good morning.
Now, let's start with the obvious question. What is the current state of the provisions of Lagos State tenancy laws, and how do they protect tenants from arbitrary increases and unlawful eviction as we speak?
Okay, thank you for the question. Now, we need to understand that Lagos State is one of the states in Nigeria, if not, a state that usually champion, causes like this. Now, with regards to the tenancy law, as far back as 2011, Lagos State has done well to enact into law a new tenancy law, which is quite different, from all administrations of the laws that we've been seeing. Now, regarding protecting the interests of the tenant, as far as law is concerned, what the tenancy law of Lagos State 2011 envisages is a situation whereby the landlord cannot just arbitrarily increase the rent, particularly considering the locality or the location of the place the house is situated. So I'll give you an example. Assuming a house is situated in, let's say, for example, or let's say, how compare the rent in Egbeda to the rent in Victoria Island. So hence, you cannot, as a landlord, increase the rent in Egbeda to match up with the rent in Victoria Island. So these are part of the protections that the law provides. And again, another thing is, a tenant also has a right to reasonably negotiate with the landlord and even institute an action in court regarding increment in rent if the tenant can show that going by the increase in this particular rent, it doesn't match up with the rent that is obtainable within within that particular locality. So if we look at it, that's basically how the Lagos State tenancy law has tried to protect the tenant with regards to rent. But I've joined your discussion, and I'm privy to what both of you are discussing in the studio. With regards to the introduction of some provisions in the Enugu State tenancy law that they are trying to do. Now, if Lagos State is trying to adopt this, we need to first consider the fact that the Lagos State tenancy law is rich in its sense. The problem that we have is the issue of enforcement. The issue of enforcement is very germane. For example, if we look at the Lagos State tenancy law, there are some provisions that the tenants are not even aware of as to using to protect themselves. Looking at Section 5 of the tenancy law in Lagos State, for example, it is an offense punishable by a fine of 100,000 for a landlord to not issue out receipt to a tenant. I know most people will not know that.
Sorry, so come again. Can you repeat that again for emphasis so that those watching can...
Section 5 of the tenancy law of Lagos State. A landlord must always issue receipts to a tenant. There are instances whereby, a tenant would take up occupation in a particular house, and the tenant must have paid the tenancy, but the landlord will refuse to issue a receipt, or will neglect to issue a receipt. That in itself is prohibited by Section 5 of the Tenancy Law of Lagos State. It mandates the landlord to always issue receipts upon payment. Assuming the landlord has failed to issue out a receipt, that is a fine punishable by 100,000 naira fine against the landlord. And we need to understand that when the law prescribes a fine can only be applied upon conviction. So that means that it is actually a criminal offense for a landlord to deliberately fail to issue a receipt to a tenant. That is what I'm trying to say. So if we also look at the provision of Section 44, subsection 1 of the Tenancy Law of Lagos State, we would also realize that a tenant is protected from forceful ejection. Forceful ejection relates to, a landlord compulsorily demolishing, compulsorily altering, compulsorily modifying, compulsorily issue threat, either oral or in writing, to a tenant, or doing any other thing that may force that can be implied as forceful ejection against a tenant. But how many tenants understand this? In fact, our law enforcement agents, do they even understand this? I'm going to share my experience with you. There was a time a client contacted me in relation to issues like this, and I looked at it. I discovered that it is a case of forceful ejection. I put up a petition against that client to the Commissioner of Police, Lagos State. The police officer to show them.
Sorry.
I had to go and get the Tenancy Law of Lagos State to show them. So that will even show that there are several provisions that are replete in the tenancy laws of Lagos State that are not even being enforced. Let's start from there before we can even now talking about adding to it. The ones that we have that relates to the rights of the tenant, to what extent has it been enforced? To what extent has the law enforcement agency, has it been able to enforce it with a view to protecting the interest of the tenant? I wouldn't want to say that the best way to enforce it is probably to create a separate enforcement body, because that may be a proliferation of the functions of the police. But again, if we look at it, whenever you have a law, for example, the Pension Reform Act of 2014, Section 17 of the Pension Reform Act of 2014 creates the National Pension Commission to enforce the provision of the Pension Reform Act. I thought about it and I asked myself, do we still need to do this for the tenancy law when we already have the police? I think those are the issues that the current tenancy law in Lagos State presents for due consideration.
Well, you've spoken a lot, and I think you've equally touched on the questions that we all had to ask, which is enforcing and ensuring that the law takes its legal course. Because whether we like it or not, we do know as journalists that Lagos State has a lot of laws that would protect both the tenants and the landlords. But it seems like the enforcing of these laws are no longer in the process. But let me ask this. What can you say about the agency fee, agent fee, caution fee, and so on?
Legal fees.
Legal fee. I am a victim. I mean, I was about getting an apartment some months back, and visiting some of the areas, we found out that this so-called caution fee that used to be a flat rate depends on the different landlords have their caution fee. So some will tell you it's 300,000, some will tell you it's 100,000, some will tell you it's 50, some will tell you it's 180, and so on. What does the law say about this, and what's the best way to address this issue?
Okay, number one, you guys still understand I'm a lawyer, so I would a little bit be sentimental towards legal fees. Of course, a lawyer is entitled to professional fees.
Yeah, but how much is the legal fee? How much?
Professional fees, my brother.
What's the percentage?
Okay, it's all right. Now, I will use myself as an example. I'm always very careful enough not to charge more than 10% if I prepare a tenancy agreement, and I will tell you the reason. Now, we seem to have a standard practice or a standard price when it comes to the issue of tenancy agreements, or when it comes to the issue of agreements in general. Although that not to say that depending on the consideration payable as rent, I may not reduce it. That's my practice. And I also believe that that should be the practice of several other lawyers. So I can directly speak to professional fees with respect to agreement. But again, have we not considered situations whereby a lawyer will not even prepare agreement at all? An agent will be charging agreement for what the lawyer should have done. That's another thing we also need to look out for. Agents taking the place of lawyers or imposing themselves as lawyers, trying to get a template of an agreement that the lawyer has already prepared and leveraging on that. That's one we have established several times. Now, let's talk about caution fee, because before we can determine whether the fees are justifiable or unjustifiable, we need to look at the etymology of these fees. To my mind, caution fee will come in a situation of, let's say, a property has just been built and the landlord wants to put the tenant in possession. Of course, there are instances where you can prevent this tenant. There are instances where a tenant may have a child or children that may practically destroy a new building or that may deface it. So that's the basis of the reason caution fee is being charged. Now, caution fee is that to caution you in the event that you damage anything here, you are going to pay. But however, even in the caution fee, I would also advise that natural wear and tear should be put into consideration. What are natural wear and tear? We all know that some of the items that they use in building houses
substandard
may not be as durable as it seems to be. Can you hear me?
Yes. We can hear you well. Yes.
Okay. So some of the items that they use in building houses may not be as durable as it seems to be. So even when I include caution fee in an agreement, I would always accept natural wear and tear. So natural wear and tear will mean that if peradventure I had bought something and it's not good, then it may not be the responsibility of the tenant to pay for it, or it may not come under caution fees. So when we say caution fees, if, for example, now I rent a house of, let's say, 1 million, and I told the tenant to pay caution fee of, let's say, 100,000, I expect that after the tenant is leaving the premises, I should come and inspect the premises. If the premises is being put in a tenantable position, exactly the way he met it, or very close to the way he met it, I also expect landlord to refund the caution fee. So when we talk of the issue of caution fee, we shouldn't look at it as an amount that the landlord will have and the landlord will appropriate solely to himself alone. No, it's an amount that when you pay, it is usually a contingency fee. In the event that you pay this money, you are moving out and probably you've damaged something, then we are going to use it to replace it, or we're going to use it to buy it.
Mr. Oguntuase,
so there are some things that are related to it. So a landlord must actually take an inventory of
now, Mr. Oguntuase, because we're running out of time, just before we go, if you can answer this question in less than 30 seconds, I would really appreciate. The landlords watching this now would be watching us and say, look, come on, guys, we're only making these increases because of the present economic realities. You've paid more for petrol, you're going to pay more for telecoms, internet, everything, food. In the last 2 years, you're part of the system, you've seen what is happening. Now, how can tenancy laws balance protecting tenants without infringing on landlords' rights to earn a profit on their investment? Quickly, if you can, please.
It's very simple. Now, there is no provision in the tenancy law that stipulates how much a landlord should charge as rent. I just believe that in everything that we do, let's apply conscience and let's apply goodwill. That's the only thing I would say. Because if we look at the provisions of the law, there are some lacunas in the law that the landlord may actually leverage on. There are some lacunas in the law that the tenant may actually leverage on. It all depends on people applying their conscience. I will not, in good conscience, go ahead and stay in a house and deliberately damage it. The landlord should not, in good conscience, exorbitantly charge for rent when the landlord knows for sure that this property doesn't go for that type of rent. That's basically what I'll be advising.
All right. Thank you so much, Mr. Oguntuase. This conversation is not going to end here. Hopefully, we'll get to have some other lawyers join us live in the studio next week. If you're opportune to be one of them, please feel free to come through. We need to dissect it using our screens and break it down. We need to understand, listen, we're going through a lot. So people having to pay rent that's increased over 400% is also a lot. But let's not talk further until we meet again and have this discussion. Thanks for your time.
All
All right.